do you think there was any overreaching during that period, and are there any specific examples?
Well, I don't want to give you any specific examples because anything I did I think is still in play and could come before the court at some point in the future. So I got to be very careful about what I say there. But when Justice Taylor ran the last time, he was quoted in the Free Press in their endorsement of him as saying that that group at the time represented the tip of the spear for a conservative agenda or something. I don't know how he phrased it. You could find it very quickly looking at that editorial endorsement in 2008. So he as much as said that they had a deliberate agenda that they were attempting to further. Now, to me, that is wrong. That is not what judges are all about. And I've said several times, I think that judges with agendas are nothing more than lobbyists with robes on, and we have no place for those in the courts of the state of Michigan. A judge's function, in my opinion, based on my experience in the trial courts and the Court of Appeals, and I think most judges would agree with me, is to bring the litigants in a circumstance where they're as comfortable as they can reasonably be in that setting, to tell you what their issues are and to listen to those very fully so that you have a good understanding of it, to apply the facts as you find them to be to the law as it exists, or vice versa, the law to the facts, and then to make a reasoned decision based upon those two factors and decide the case at the earliest possible time. And my definition of a reasoned decision is one that even if you were to lose the case, other than the disappointment of having lost, after you settle down a little bit, you look at that, you can say, well, I may not agree with the judge, but I can see how the judge got to where they got, okay, how this judgment came about. And I think that's about the best we can do. Now, there's another aspect to your question, and that is one of the principal tenets of legal decision-making is something called stare decisis, which means that the court and a judge is obligated to follow the law as it exists, and the law has evolved over time. It changes, but it changes slowly. And the reason for that is so that people know what the law is, and they can depend on it in their business dealings, and they can reasonably predict what's going to occur depending on what they do. So we adhere to the principle of stare decisis. Now, it's not inviolate. You might say, okay, things have changed. We've got new technology. We've got something going on here. And the law as it existed will need to change somewhat to accommodate this new circumstance. But then the second point kicks in, which is you make the smallest possible change from what existed to where you need to be in order to resolve the issues before you. And you go forward in that way so that there's ample opportunity for adjustments, but they're always kind of micro adjustments as you go forward, so you're not having these major sea changes. That's where I think the court got away from things in the recent past. And I think if you were to do in some of these areas where they have had their strongest pronouncements that you'd be most likely to be aware of, I think you'd see if you did a graph, let's say just pick from the 50s, you'd see a straight line, and then when these folks are here, you'd shoot up. You'd see some real deviation from the norm of substantial magnitude. The problem we're going to get into there is, assuming for the sake of our discussion that my representations to you are accurate, and I think they are accurate, getting back to the norm is going to create another major move, just coming back to normal. And so that presents a little bit of a problem.